नमस्कार, मैं हूं मनोज टिब्रेवाल आकाश। एक मुलाकात में आज हमारे साथ हैं बेहद खास मेहमान, सुप्रीम कोर्ट के वरिष्ठ वकील और भारत के सॉलिसिटर जनरल मोहन पारासरन जी। 9 साल तक भारत के अतिरिक्त सॉलिसिटर जनरल रह चुके मोहन पारासरन जी को इसी साल देश का सॉलिसिटर जनरल नियुक्त किया गया है। मोहन पारासरन जी के पिता भी देश के नामी वकील रहे हैं और उन्होंने भारत के अटॉर्नी जनरल के तौर पर देश की सेवा की है। आज हम मोहन पारासरन जी से तमाम सवालों पर विस्तार से बातचीत करेंगे। मोहन जी, आपका स्वागत है दूरदर्शन की इस खास पड़ताल एक मुलाकात में।
थैंक यू।
देश के सॉलिसिटर जनरल के तौर पर आपका कार्य है क्या?
देश के सोलिसिटर जनरल, he is the second highest law officer of the country for the government of India, and Solicitor General has to mainly defend the government of India before the Honorable Supreme Court in important matters and also advise the central government on various legal issues, and he is frequently also called by important government dignitaries to give advice on important constitutional questions and other important matters concerning governance.
अटॉर्नी जनरल और सॉलिसिटर जनरल के काम में मेन अंतर क्या है?
Attorney General, it's a constitutional appointment. The Constitution creates the office of the Attorney General, like Chief Justice of India, President of India, like the judges of the High Court, likewise the Attorney General of India. And only a person who is qualified to be a Supreme Court judge is appointed as the Attorney General of India. The Solicitor General is virtually a non-statutory post, but it's also a very equally important post like the Attorney General. He is the lieutenant virtually of the Attorney General and supposed to take all the burden of arguing cases before the Supreme Court. And both the Attorney General and the Solicitor General are given, I think, due importance, and opinions are divided amongst them by the government, and they both are expected to advise the government on very many sensitive issues, even though the role of the Attorney General in advising the government is far more greater, since the Attorney General also has a right to address Parliament.
मोहन साहब, अभी हमने कुछ दिनों पहले देखा देश में काफी बवाल मचा। जो दागी मेंबर ऑफ पार्लियामेंट और एमएलएज होते हैं, यदि इनको सजा हो जाती है तो ये चुनाव नहीं लड़ पाएंगे। इस बारे में अध्यादेश एक बार राष्ट्रपति के पास गया, फिर कैबिनेट ने इसको वापस मंगाया। मेरा सवाल यह है कि वाकई यदि सजा याफ्ता एमपी और एमएलए अगर चुनाव नहीं लड़ पाएंगे तो क्या वाकई चुनाव सिस्टम में और ज्यादा सुधार आएगा?
Yeah, the system requires to be completely be changed. But as far as the said issue which happened few days back, I personally feel now there are two important controversies going on. See, the Parliament or the legislatures or the governments have been saying that the judiciary is overstepping and getting into the role of the executive. Likewise, the judiciary also sometimes feels that Parliament can't arrogate itself the power to decide judicial things. Now, if you take this ordinance, what happened? By the ordinance, they say if a particular MLA or MP is disqualified or is convicted for an offence by a court, he stands disqualified. Now, what the ordinance did was, he has a further right of appeal from the High Court after being convicted. The ordinance said, pending appeal, he will not lose the office of MP or MLA, but he will not have a right to vote. That who can say? It is only for the judiciary to say by passing an interim order in an election case. The parliament can't actually say, pending appeal before some court, he can participate, but he won't be allowed to vote. That is not a law-making power. There you are trying to decide as a judge. And they wanted to straightaway knock off the judgment of the Supreme Court without a constitutional amendment. Apart from all that, the public reaction. What was the reaction of the Aam Aadmi? Every Aam Aadmi felt that this ordinance is suddenly being passed to save some people who are likely to be convicted. And widely, I think, all electronic media, press, etc. were immediately naming a particular politician from Bihar. And that is why I think seeing the public mood and so many other factors, including the legality, possibly the government had a rethinking and the ordinance was withdrawn.
एक और बड़ा सवाल है, अभी हाल के दिनों में सुप्रीम कोर्ट ने यह व्यवस्था दी कि वोटर्स को अधिकार मिले राइट टू रिजेक्ट का, और जो ईवीएम मशीन होगी उसमें राइट टू रिजेक्ट का बटन होगा,
फोर्थ बटन।
आपको क्या लगता है किस तरह का परिवर्तन आएगा इस निर्देश के बाद? क्या यह उचित है?
I personally feel that this is a sort of a retrograde step. There is a negative step. See, there are some countries where right to vote in an election is made compulsory. And as far as India is concerned, the Supreme Court has actually said the right to vote in an election is only a statutory right. That is, statutory right means every citizen has got a right to vote in accordance with the mandate laid down under the Representation of People Act, read with the Constitution, but it is not a fundamental right. Fundamental right comes under the Constitution. Right to life, right to speech, freedom of expression, right to travel abroad. These are things under the Constitution, fundamental rights. Now, Supreme Court seeks to use a fundamental right, that is freedom of expression, thought, and says that even though you are exercising a statutory right, you also have a fundamental right to express your views and you have a right to reject persons. When it is a statutory right, what I say is, if the right to vote itself is given only by a law, not by the Constitution, you can't use the Constitution and create a fourth right, no? Right to reject. And this will actually only send negative signals. Instead, what I will say is, had the Supreme Court said that every citizen, in the light of the Constitution and the principles contained therein, should compulsorily vote, except suppose if somebody is unwell or somebody can't go and vote physically, they will be excused. But all citizens should actually participate in a democracy. That would have been a positive step.
मोहन पारासरन जी, देश में एक माहौल सा बन गया है कि सुप्रीम कोर्ट अप्रत्यक्ष रूप से सरकार चला रही है। जब भी महत्वपूर्ण विषयों पर सुप्रीम कोर्ट अपना निर्देश देती है तभी सरकार जागती है। क्या यह लोकतंत्र में उचित है?
See, it is always not good, no? The courts have to confine themselves within their jurisdiction. See, our own constitution, our founding fathers in the Constituent Assembly, Dr. Ambedkar, or you take Sir Alladi Krishnaswamy Iyer, all of them have said that the courts are expected to decide on the validity of a policy of the government from a constitutional angle. They don't step and make policies, because the court is not answerable to anybody. Suppose if they make a policy and that policy actually goes for a 6, for instance, education, if the Supreme Court frames a policy with regard to admission of students, and that results in something wrong, in some evil, government could not legislate because of Supreme Court framing a policy. Suppose it has caused prejudice to students, then who is answerable to them unless the court overrules its judgment? At least in a democracy, the government, if it takes a call, normally the government is responsible to Parliament or Assembly. Normally. And now after the Right to Information Act has come, every citizen has got a right to know what exactly is happening in the government. Every move of the government, including passage of bills, your file notings, are all coming outside. Everything becomes transparent. But now when it comes to Supreme Court, nobody can go and ask the Supreme Court that, come on, what operated in the mind of a judge to give this particular judgment? Or give me the particulars as to how your institution is working. Or how did you recommend X, Y or Z to become a judge? Those are all not, the Supreme Court itself has clearly said we won't disclose. These are all matters pertaining to our administration, confidentiality. Therefore, we won't disclose. Therefore, what I am saying is the courts are not answerable to anybody. So, keeping that in mind, possibly the courts should not step into policy making. But I also tell you one aspect. Now, these days, we have seen right from 1996 onwards, our country has throughout been having no single party in power. No? If you see before 1996, the interference of the courts was very, very limited. After 1996, the governments are unable to take a decision because of coalition dharma. In view of the fact that there is a coalition dharma putting actually brakes to government policy making, many, I think, policies went for a 6, there is a gap, and Supreme Court thought till the government actually takes a call on a particular burning issue, they will step in and take a call. So, this is a very delicate area. Sometimes I think government not being able to take a decision, Supreme Court coming in, or the High Courts stepping in and taking a call, and even actually trying to frame rules or regulations as to how some schemes have to be administered, including, as I said, admission of students in professional colleges, banning of capitation fees. All this was done what? In the year 1996 by the Supreme Court. Then only I think governments have started slowly waking up. So this is the real problem. No? If the government has all the majority and it is not going to be actually stopped from taking decisions freely, then possibly those were days the court also will look, oh, we have a very powerful government, a powerful prime minister. Therefore, they are actually ruling the country. Therefore, let us actually keep away. So, that is the real position, I feel.
एक और बड़ा सवाल है मोहन जी, कई बार देखने में आता है कि अटॉर्नी जनरल और सॉलिसिटर जनरल की जो राय होती है उससे सरकार की राय मेल नहीं खाती, खास तौर से लॉ मिनिस्टर के साथ. तो ऐसी नौबत ही क्यों आती है?
Yeah, it happens, no? You are trying to say that sometimes there is a conflict between the various law officers and also the role of the law minister. Now, as far as the law minister is concerned, if we speak the present law minister, I think he has also brought about, when we are talking about the roles of all these people, I think he wanted to convince all the parties and wanted to take away the power of appointments from the judiciary. Because from your question, I am only going to just go to one aspect, which is again a very sensitive aspect, which has to be dealt with by the Attorney General, other law officers and the law minister. And he felt that possibly, since judges themselves are appointing themselves, and that even when it comes to removal of a judge, it has to be first sanctioned by the judiciary. I think possibly there is a feeling amongst all political parties that judiciary has kept itself immune from being actually tinkered with, right in the matter of appointments, in the matter of even removal, and all the powers completely vested only with the judiciary itself. And they introduced the bill. Bill has been passed. There have been lots of comments from various people. Bill was passed in the Rajya Sabha, but for some reason it could not be brought in the Lok Sabha. And some jurist was commenting that when this power was with the government, previously the government alone had the power, in consultation with the Chief Justice of India, for appointment of judges to the Supreme Court, and for High Courts in consultation with the Chief Justice of the concerned High Court and the Chief Justice of India. And there was no complaint. There are great judges. India produced great judges. See, like Justice Mahajan, Bose, Justice Patanjali Sastri, Justice V.R. Krishna Iyer, Justice Bhagwati. All these people were appointed only by the government when this was not there. Now the argument is, after this power went to the judiciary, there have been some bad appointments. And there have been lots of criticism. There were impeachment motions brought against some judges, Chief Justices of High Courts. And there are controversies qua some Chief Justices who retired from the Supreme Court. Therefore, why is this happening? Therefore, why not we actually bring in some other independent body to monitor all this?
लेकिन बड़ा सवाल ये है कि जुडिशरी से करप्शन को दूर करने के लिए क्या कुछ किया जाना चाहिए?
See, what I feel is corruption should never actually enter the judiciary. If it enters the judiciary, I think democracy, there will be a death knell to democracy. Because every common man today has the ultimate faith only in the court. Every common man knows, okay, corruption is there in every government office or whatever it is. We know if we pay 100 rupees or 200 rupees, we can get small things done. But when it comes to court, they have got the belief. But unfortunately, I think even it has been commented upon by even some judges that corruption has actually somehow entered the subordinate judiciary. But we have seen other instances, as I said. But what I say is ultimately there should be transparency, and they should be allowed to freely talk, but at the same time we must also not loosely talk about the institution. Because if you start loosely talking about the institution that so-and-so is bad, so-and-so is corrupt, then it is only going to affect the court. And if courts are gone, then our country will become like Pakistan.
दुनिया के अन्य बड़े देशों की तुलना में भारत में वकालत का किस तरह का माहौल है?
Now actually, Supreme Court lawyers, I will straight away say, senior advocates, the top 10 vakilo, 10-15, I don't want to name the advocates, they are actually earning much more than Shah Rukh Khan. And their day fee ranges between, say, 25 lakhs and some case even 40 or 50 lakhs per day. And if a case goes on for 20 days, you count, 40 lakhs into 20. And if you see their returns also, obviously I think some income tax officer commented, I think it is better to be in Tilak Marg than in Bollywood. But at the same time, there are many lawyers who are also struggling in the district courts. They actually chase people, get commissions, they go with the wakalats, please sign, and whatever you get, we'll share. You do not have to pay fees. They are called ambulance chasers. So, majority of them, I think, are ambulance chasers in India. There are touts. That has to be controlled by the Bar Council of India. But in Supreme Court, there are 5-star lawyers. There are 5-star lawyers, there are 3-star lawyers. Though you have categorized, no? Okay, this guy, this lawyer, this senior counsel, if you go, you'll have to pay him 50 lakh or 25 lakh. That is his fees. There are some people 5 lakhs, 10 lakhs. It's like AC first class, AC 2 tier, AC 3 tier. So that is a classification.
जो नौजवान ला की पढ़ाई के बाद आपके जैसा नामी वकील बनना चाहते हैं, उनको आपकी एडवाइस क्या होगी?
So I would actually advise for the future younger generation. Now all of them want to study in national law schools. There's a mad rush for admission. Those days, admission into law college was the most easiest thing. If you don't get admission anywhere, then you go and join the law college. And in Madras, I used to see V.K. Krishna Menon, you know. He was the principal of the Madras Law College. And he used to stand outside and call people, come join. But today, admission into law college has become more difficult than getting into a medical college. There's lots of money, and if you study in the national law schools, you are actually taken away immediately after passing out by multinationals, by law firms, top class law firms, both national and international, and most of them don't come in for live practice. You know. What I feel is lawyers have I think these students, like medical students, have to contribute a lot to society. See, they are the cream, and lawyers only have shaped up this country. Freedom fighters were lawyers right from the Mahatma, or Sardar Vallabhbhai Patel, or Jawaharlal Nehru. And I think, like doctors going to villages, the younger lawyers should take a vow that they should actually start practice at the lowest level, not be weaned away by financial considerations, try to improve the efficiency of the system. The government also, when Mr. Veerappa Moily was the minister, unveiled reforms in law. They were also trying to encourage them by providing a financial package. And they should actually come to actual practice thereafter. Some can also come to the High Court, some later on to the Supreme Court. But I would only appeal to all those people to not to get drained away to some other system, but come into the Indian system and help the society. And also come and actually practice law, live practice. We are losing, because we have created the national law schools by government money, and we are providing subsidized education in the national law schools. Government has given the land, government created infrastructure, but you take advantage of the government and you go and serve foreign agencies. You have to instead serve the country. That's my humble appeal to those students, and generally to all other lawyers, to actually follow integrity and honesty. The impression is lawyer means only telling lies. Vakil, what? Yeah. That is the reputation of an advocate. That you have to change that impression.
आपके पिताजी भी देश के नामी वकील रहे हैं. बतौर अटॉर्नी जनरल ऑफ इंडिया देश की सेवा की है. उनके बारे में कुछ हमें बताएं.
See, they belong to a different generation. And they had lots of values. See, what I'm saying is, like my father, Mr. Fali Nariman, Mr. Solisitior, or you can take the earlier generation, Mr. Nani Palkiwala, Mr. H.M. Sirvai. They actually were not bothered about money. Money was the last. And they used to demand only check payments. Now actually it's all like real estate, 50-50. And they always actually stood to the truth. If something is wrong, they will say, actually, I will not appear on the matter. But now, even if some crook comes, okay, I am prepared to appear so long as you pay my fee. So, what I say is, you can't compare these. They were so knowledgeable, Nani Palkiwala or Sirvai, they were so knowledgeable in so many other branches, not only law. What we can learn from them is a lawyer should be a multifaceted personality. You must know literature, you must know about religion, you must know various languages, you must know politics. So, like Chanakya says, for a mantri means you must know all the three columns, past, present and future. He is called mantri. Likewise, those were lawyers who had vision of all the consequences.
आखिरी सवाल, आपके जीवन का एम क्या है?
See, my aim is actually to continue practice. I don't have any ambition to get to the bench or become a judge. Nor I am interested in politics. Practice law and possibly with whatever income I earn, whatever extra I have, substantially actually do social service. And I have actually been working in that direction in the past few years. Even as a government law officer, your income goes down. But I think I had to wait for my own time to get into private practice. While I was practicing in Madras, I had more freedom to help various organizations which are helping the poor, the physically handicapped, mentally retarded. Therefore, I think I am more into that line.
बहुत बहुत धन्यवाद दूरदर्शन से इस खूबसूरत बातचीत के लिए। तो ये थे सुप्रीम कोर्ट के मशहूर वकील और भारत के सॉलिसिटर जनरल मोहन पारसरन जी। इन्होंने हमारे तमाम सवालों का बेहद बेबाकी के साथ और खूबसूरती के साथ जवाब दिया। अगले सप्ताह आपसे फिर मुलाकात होगी ठीक इसी समय आपके अपने लोकप्रिय कार्यक्रम एक मुलाकात में, देश की एक और बड़ी हस्ती के साथ। तब तक नमस्कार।